let this be a normal field trip? With a friend? No way!
Cruising on down Main Street, you're relaxed and feeling good. Next thing that you know, you see it. Octopus in the neighborhood, Magic School Bus. Step inside, it's a wild ride. Come on, ride on the Magic School Bus.
Hi kids, I'm Miss Frizzle. Welcome to the Magic School Bus Government Edition. Today we're going to learn about the foundation of the U.S. government, like what the government can and cannot do. Hop on the Magic School Bus and we'll journey back to 1803 where we'll learn about our first case, Marbury versus Madison. Now that it's 2015, we've upgraded the Magic School Bus into something a little bit more fuel efficient. It's good for Mother Earth, kids. Now let's hop in the Magic RAV4 and get going. A little bit of background on this case. When the federal government was first established, it was still unclear exactly what powers Congress held and what the judicial branch was supposed to do to regulate these powers. So in 1803, Thomas Jefferson, via his Secretary of State, James Madison, prevented William Marbury from taking office as a Justice of the Peace for Washington, D.C. because of the previous president, John Adams' midnight appointments. Marbury then sued Madison to secure his position as a judge. And now let's journey through the Magic RAV4 and head to February 24th, 1803 to the Supreme Court where this case was tried.
I, John Marshall, rule in favor of Madison by finding that the Judiciary Act of 1789, giving legal authority to federal courts to order government officials to act, was unconstitutional. First, Marbury had a legal right to be a Justice of the Peace. Second, Secretary of State Madison violated this right by withholding the commission. Third, the right of mandamus was a proper way to direct a government official to carry out his duty.
Wasn't that interesting, kids? Did you know that the court established the guiding principles of judicial review in the ruling of Marbury versus Madison? The case recognized the federal court's role in reviewing acts of Congress and states regarding their constitutionality. The Supreme Court thus became a significantly powerful part of the American government system. Let's move on to McCulloch versus Maryland on March 7th, 1819. Let's get back into the Magic RAV4. Fast forward in time. A little bit of background on this case, kids. The state of Maryland attempted to impede the operation of a branch of the Bank of the United States by imposing a tax on all of the notes of the banks not chartered in Maryland. And James William McCulloch, who worked for the bank, claimed that a Maryland state tax imposed on the Bank of the United States was unconstitutional interference with federal government activities by the state. Here we are, kids! Look, it's Daniel Webster, McCulloch's chief lawyer. Congress has the constitutional right to charter a bank and its branches. Even though the Constitution does not actively enumerate the power to charter a national bank, the state cannot tax a federal authority, and a national bank is necessary and proper.
I, Justice John Marshall, rule that congressional powers actually listed in the Constitution, such as the powers to issue money, borrow money, collect taxes, maintain armies, implied that Congress could do whatever was necessary and proper to carry out these activities, including chartering a national bank.
What can we take away from this, kids? We just learned about how the necessary and proper clause was established and incorporated into the foundations of our government. Marshall's ruling enabled Congress to undertake activities not specifically enumerated by the Constitution, but nevertheless implied. Let's go to March 2nd, 1824, to witness the Supreme Court's ruling on Gibbons versus Ogden. Now, Thomas Gibbons sued Aaron Ogden, claiming that a New York state law granting exclusive rights to individuals to operate steamships in New York waters while conducting interstate commerce violates the Constitution's Commerce Clause. Let's visit our old friend Daniel Webster to see what he argued in favor of Gibbons. New York state law granting exclusive rights to individuals to operate steamships in New York waters while conducting interstate commerce violates the Constitution's Commerce Clause. This is tyranny and injustice. The power of Congress to regulate commerce is complete and entire, and to a certain extent, exclusive. Also, I contend that the term commerce includes navigation necessary to conduct business transactions. Therefore, Gibbons' federal license takes priority over New York law.
Calm down, sir. I agree and rule in favor of Gibbons. Steamship navigation is a part of commerce, and states cannot pass laws regulating steamship traffic operating between two or more states.
Wow, kids, how passionate! That's a cool piece of judicial history. This landmark ruling was the first to interpret federal powers under the Constitution's Commerce Clause. It provided a broad interpretation of what is commerce under the clause, holding that commerce was more than simply the buying and selling of goods, and forming the basis for numerous rulings involving the Commerce Clause throughout the history of the United States. This case also deals with the foundations of our government. Alright, let's move on to April 26, 1995 to learn about United States versus Lopez. Alfonso Lopez was a 12th grader who was found to be carrying a firearm on a school campus, which is thus in violation of the Gun-Free School Zone Act. Lopez moved to dismiss the charges on the grounds that it was unconstitutional for Congress to have legislative control over public schools. Oh, here we are now!
I have been attempting to explain Congress's rational basis for a connection between gun-related violence in schools and interstate commerce all day. In my opinion, such violence significantly undermines the quality of education that is critical to economic prosperity. And teaching and learning are linked to commerce, which is threatened by the presence of guns in schools.
I object! Meddling in the affairs of interstate commerce was not a power given into the Constitution, and thus the act is unconstitutional. And now that we've seen both arguments, I can tell you the ruling. The Supreme Court ruled that the Congress had overstepped the boundaries of the Commerce Clause, and the act was deemed unconstitutional. The ruling dealt a large blow to Congress's attempts to cut down on school-related violence and improve the safety of America's schools. However, the Violent Crime Control and Law Enforcement Act of 1994 was able to fill in some of the gaps left open by the striking down of the Gun-Free School Zone Act. Now let's get back to the Magic Round 4 and journey to Virginia Tech to learn about the case of U.S. v. Morrison. The year is 2000, and Virginia Tech students Antonio Morrison and James Crawford have been accused of sexually assaulting fellow student Christy Brzonkola. Let's go to a news reporter and see what she has to say about this developing case.
During the school-conducted hearing on her complaint, Morrison admitted to having sexual contact with her despite the fact that she had twice told him no. College proceedings failed to punish Crawford, but initially punished Morrison with a suspension. However, this punishment was later struck down by the administration. Let's go to the live feed from the Supreme Court, where Judge William Rehnquist gives his ruling.
I will now announce the court's decision. In a 5-4 decision, the court holds that the section of the Violence Against Women Act of 1994 that gives victims of gender-motivated violence the right to sue their attackers in federal court unconstitutional, although program funding remains farther unaffected. We rule that Congress lacks the authority, either under the Commerce Clause or the 14th Amendment, to enact this section of the Violence Against Women Act. Alright kids, Morrison was part of a series of Rehnquist court decisions from 1999 through 2001, holding that Congress's enumerated powers do not permit various federal civil rights. The United States v. Morrison decision was also seen by the press as part of the Rehnquist Court's series of federalism decisions, mainly because of the court's previous decisions in Lopez and other cases. Alright kids, I hope you were paying attention for the quiz at the end. Thanks for coming on the Magic School Bus, and we'll see you next time.